And affidavits are a summary of the words of the deponents,
Yes.
but reduced into writing by an advocate who is the draftsman. Were it to be oral testimony, my grand brother would go to the unsafe way of saying coaching. But your worship, we are saying that these affidavits, since it's three people who were narrating about the same incident, appearing at the same time, who were there at the same time and place, having a similar opinion about the particular set of facts is natural and normal. I want to use a simple example here. If you are to
So you're saying it is normal?
normal,
Normal having
same arguments
same arguments?
about particular set of facts
Okay.
which they witnessed at the same time and place.
Set of facts.
Yes.
Okay.
If I would make an conventional example, if I was to make my senior brother to stand up, we all look at his beards. If all of us say that there is gray hair in black hair, would not be wrong, all of us here. And that is what is happening right now. People narrating about similar facts at the same time. You can say to my senior brother.
Okay.
Yes. So, Your Worship, it's a humble submission. My own brother will add on, but it's my
I've taken note.
it's humble submission that all these preliminary objections
Okay.
are objection.
So you pray.
If I make a prayer, there is a case of Rutuk Francis.
Case of
Rutuk Francis.
eh?
Rutuk. Rutuku Francis. And 5 others. Brothers, Erfas Ndamaje.
Erifasi.
Erfas Ndamaje. It's the decision of Justice Varshat Cheborian in civil application number 111 of 2017, arising from civil appeal number 80 of 2017.
So that is Court of Appeal?
Court of Appeal,
So Court of Appeal.
civil application number 111 2017, arising from civil appeal number
Court of Appeal civil application.
number 80 of 2017.
Number 80.
Of 2017. Your Worship, at page 10, the Land Trial Judge, relying on the Supreme Court case of Kano Chizabe CJ, verse Museveni Yoweri, Electoral Commission, which is Electoral Commission number 1 of 2001, observed that a liberal approach in dealing with affidavits, that Supreme Court adopted a liberal approach in dealing with affidavits that contain some falsehoods, and appealed that the position that the first parts of an affidavit, which were irrelevant to the matter at hand, could be ignored.
False.
Parts of an affidavit, which were irrelevant to the matter at hand, could be ignored and the rest of the arguments considered. And the land judge of appeal observed that I'm bound by the same approach in dealing with affidavits in this application. So we are bringing this authority on board. And your ship,
It is covering which paragraphs?
it will be covering the aspect that some governments,
Like which ones? That's what I'm asking. Which paragraphs is it covering so that I should apply the authority to cover them that are false.
then I'm not saying they're false, but according to their contention, with their contention,
Okay.
they said they attacked the aspect, paragraph 2, when they said that I was created by Electoral Commission as one of the journalists to cover the overseas election and did not attach the data.
Okay.
Your Worship, so we are saying that
For that
all,
paragraph.
and all their misfeedings.
How about the paragraph to do with we? Should
We.
we also apply the same?
But Your Worship, I don't find it offensive at all.
No.
Right.
I want to know where I'm
But
going to apply
it
that.
can equally apply, Your Worship.
That should also apply?
Your Worship, should court choose to find the word we offensive, which we don't say it is,
Okay.
then it can, that
Okay.
authority would be applicable.
Okay.
Then Your Worship, coming to the aspect that the affidavits are having similar words, at page 11, the land judge,
I beg not to interrupt my land friend. But can we give favor with an authority?
We are giving you an authority.
Then supplying
your time for joining is coming. I'm going to give you a copy. I'm going to give you a copy, don't worry. Let's get it. We are giving you a copy.
That authority is extensively being relied on. And
We are giving you a copy, my brother.
Noted, noted.
We are getting you a copy.
Kindly extend your capital.
It's okay. We will. The land judge warned that I would like to caution the council who act for litigants to endeavor to draft affidavits with precision. So, Your Worship, when we are using words that appear to be similar, we are trying to meet this requirement to avoid unnecessary errors and to use precision.
Okay. You highlight the pages and you also give them copies.
Yeah. No, we have another copy.
And so, is that the end of your submission?
Yes, my worship, Your Worship, I'm saying that the rest, it's my prayer that you disregard
Okay.
the objections because they are not well premised. My land brothers wish to add something.
Council, do you want to supplement?
Your Honor, very briefly,
Maybe just give me a minute or two. I'm coming. Let me have a commercial break. As you share the document.
Right. And having this as we
Honorable, yes?
Your Honor, I just want to make a very brief supplementary.
Please let us listen to each other.
Very brief supplementary
Yes, go ahead.
submission
On which area?
on the competence and validity of Mr. Alan John.
Mr. Alan John?
Yes,
Okay.
to swear an affidavit. Your Honor, counsel for the applicant took issue with government number 2, respondent's additional affidavit in reply, and sought to discredit it on account that there was no attachment of accreditation from the Electoral Commission as one of the journalists to cover the aforesaid election. Your Honor, I wish to draw the attention of court Order 19.3, which is to the effect that affidavits to such facts as the deponent is or her to prove his or not to prove. Honor, why a deponent is in an affidavit that he or she saw, he or she heard, he or she was present, then that deponent meets the requirements of Order 19, Rule 3.
Okay.
We therefore submit, Your Honor, that this affidavit of Mr. Alan is in pari materia with Order 19, Rule 3, and therefore it should stand, Your Honor. Your Honor, Justice Mubiru in the case of Matilda, we shall provide it. Matilda versus Semanda Simon and two others. Semanda Simon and two others. Miscellaneous application number 430 of 2021. Said, part of the ratio disdained, Your Honor, he said, what is required in affidavits is the knowledge or belief of the deponent. Knowledge or belief of the deponent. That is what is essential in an affidavit. Your Honor would therefore maintain that that affidavit is competent. Finally, Your Honor, on the issue of authorization, because Your Honor, you were asking for...
No, I thought that was going to be responded to by counsel for the second and third respondent.
Okay. Then I'll leave it at that, Your Honor.
Okay.
It please Your Worship, Kayondo Abubeka, for the second and third respondent. Your Honor, in reply to the objection by my learned brothers for the applicant, that lack of an affidavit by the returning officer is an admission of the application. Is out of context. Submission out of context. Your Honor, the authorities cited by my learned brothers, that's the authority of Samuel Massa, cited above, is distinguishable to the facts before this case. Your Honor, the facts in Samuel Massa refer to rules of affidavits. In ordinary civil matters. Yet the electoral matters are different in their special circumstances and procedures provided for under them. Your Honor, in this we submit that Chobutunji Jennifer was not or is not being sued in her capacity as Chobutunji Jennifer. She's being sued as a returning officer, and therefore as an office, not an individual. Your Honor, if she does
So you
not,
say she's not sued as in her capacity, but
as Chobutunji, but as an officer, as a returning officer of the Electoral Commission.
Yes.
As a returning officer of the Electoral Commission. Your Honor, this can be seen from even the drafting of the application. The drafting of the application is showing Chobutunji Jennifer as an individual, much as they put in brackets returning officer. So our submission is that if she's being sued as a returning officer, if she has not deponed an affidavit in her capacity, as Jennifer Chobutunji, or even as a returning officer, Rona, it is not fair, and it does not render does not render the evidence, of a presiding officer, a one Munanura Ivan, inadmissible. Because the submission of counsel is that the affidavit should not be admissible before this court. Now we are saying the law in section 66 of the Parliamentary Elections Act, it bestows upon the duty of counting upon a presiding officer, not upon the returning officer.
Okay, for starters, are you in agreement that she did not swear an affidavit?
Yes, I am. She did not. She did not, but we are saying it is not fair. Saying it is not fair. And the reason is section 66 of the Parliamentary Elections Act.
What does it say?
Your Honor, we may read it. Section 66 provides that votes at a polling station, that is subsection 1, votes cast at a polling station shall be counted at the polling station immediately after the presiding officer declares the polling closed.
So precisely, you seem to say that
The affidavit
it was not necessary for her to record an affidavit.
Yes.
In simple terms.
Yes, because the presiding officer is the counting officer, if I may use that one, is the counting officer, not the returning officer. That's what the law provides.
So precisely the affidavit that is on record pointing to the second and third respondent basically should be
That evidence is,
attributed to only the second respondent.
that affidavit is sufficient for both. It is sufficient for both the second and the third respondent.
Because you just told me she did not swear an affidavit. That's what you told me. That the third respondent did not swear the affidavit because it was not necessary. So in simple terms, the affidavit pointing to the second and third respondent is basically attributed to only the second and not the third.
No, Your Honor,
Or I'm mixing up.
I think we are not at par. What I am saying in simple terms, I'm saying the Electoral Commission is a body entrusted with the duty of conducting the election.
No problem, because here the point was, his argument was that the third respondent, by implication, did not swear an affidavit. You get me?
Yes.
Now, as for the implication, that is another story. Because to him, his implication was that because he did not swear the affidavit, the information to do with
He's saying that it is admission of the facts. That's what he's saying.
and they're saying it's not.
We are saying
admission.
it's not an admission.
Okay.
We are saying it's not an admission, and the reason is clear. The application is based on counting. This is an application for a recount. It's not an application against the process, because that would be a petition.
Okay.
That is our argument.
Okay.
So that's why I bring in section 66 to buttress the fact that the presiding officer, who was the counting officer, is properly giving evidence in the affidavit, which covers that requirement.
That's why you said in simple terms, it was not necessary to record to have the affidavit of the third respondent.
That's the reason.
Okay.
That's the reason. Luna, I think we are at par, because I really believe we are at par. What I'm trying to say.
We have no affidavit for the third respondent on record.
Your Honor, the affidavit we have is for...
No, from a summary of what you've just told me.
Yes.
Yeah, because you seem to say, okay, much as she never recorded one, it is not fatal because the presiding officer had recorded one.
And the process is this application.
Exactly. So basically I'm saying, for that matter, one should say, we have no affidavit of reply for the third respondent on record.
Yes, Your Honor. And the reason is that the deponent is an employee. Both of them, both the returning officer and the presiding officer are employees of the second respondent, who is the manager of the electoral process. And we are saying that if there is an affidavit of the presiding officer provided for under the law, it is sufficient evidence. It is sufficient evidence. And we are saying it is not an admission. Your Honor, therefore the affidavit of Munana is sufficient for the two respondents, the second and third respondent.
You're mixing me up now. Because you just told me the third respondent did not record an affidavit.
That is true. We have agreed. And we are saying that the facts depend upon by Munanura Ivan.
They cover both of them.
Yes.
Oh.
They cover both.
Munanura Ivan. It's called Ivan.
Yes, Munanura Ivan.
Cover the third respondent.
Yes. Yes.
Okay.
Your Honor, the second leg is in respect to the authority.
Okay.
The authority. To the authority to have capacity to swear an affidavit from the principal, who is electoral commission. Your Honor, the law in the case of Matilda Namda versus Semanda and others, business application number 430,
In the case of
Matilda Namutebi Bazila,
Matilda
Namutebi
Mantevi Bazira.
versus Semanda and others.
Semanda.
That is miscellaneous application number 430, 2021.
Yes.
Justice Mubiru ruled that where there is no written authority to swear, where there is no written authority to swear on behalf of others, that affidavit is not defective. That affidavit is not defective. Your Honor, under section 14, subsection 3.
Under section.
Section 14, subsection 3 of the Electoral Commissions Act. The
Elections
Commission,
Commissions Act.
yes, Electoral Commissions Act. The Commission can assume,
And assume.
and perform duties of any officer,
beg the pardon of the section.
Section
Section
14,
14,
subsection 3, the Electoral Commissions Act.
And they're saying the commission can assume,
Yes.
perform duties of any.
Election officer. My learned brothers were arguing that commission cannot perform any duty. It cannot do anything.
No, he was specific on the count. Also, he seemed to suggest that when it gets to a mandatory account, it is only the returning officer, without the returning officer giving Munanura written authority. That is what I understood.
And our argument is the electoral process is managed by the electoral, not managed by an individual. The electoral process is managed by the electoral, not managed by an individual. It's managed, it can even be managed by assignment of the electoral commission of any officer. Like in practice, it can even commandeer vehicles from other ministries and they perform their functions without a written authority. So it is not true that there must be a written authority to either perform an assignment on behalf of the commission, written authority.